Good morning, all.
Good morning.
Good morning.
Good morning, Justice Hennessy. Before we introduce our new witness, I think I'd like to address the idea of breaks for today, since we're starting an hour early. And
Good
I would
idea.
propose that we try to go through till 10:30, take a 15-minute break, come back at around 10:45, do another hour, take another 15-minute break, 11:45 to 12, another hour, and then we'll be on our regular schedule for a 1 o'clock break, if that works for people.
In your hands.
Great. I
Very
wanted
good.
to mention that because I know people may be anxious about knowing, since we're a little bit off schedule today. So we'll try to go through till 10:30. So we'd like to call Dr. Barbara Messamore as our next witness, and I would ask that the witness be sworn in, please.
Can you please state and spell your name for the record?
Barbara Messamore. Spell, sorry, Messamore.
Do you solemnly affirm that the evidence to be given by you to the court touching the matters in question to the parties shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
We have a few documents to enter. I'm going to enter some of them now and some of them a little bit later as we go. But the first one that I'd like to enter is the qualification statement for Dr. Messamore that has been agreed to by the parties. And I believe the court clerk has just provided Your Honor with a copy of it.
Thank you.
So if we were to mark this as an exhibit, which I'd like to do, I believe it would be exhibit 77.
Correct.
Can we mark this as an exhibit then?
And I take it you're telling me this is on consent?
Yes, it is. And all of the parties have agreed on the qualifications of Dr. Messamore as set out in this document. So I'm going to go through this document and then later I'll ask Dr. Messamore to elaborate on her qualifications. And at that point, I'll ask you to, we'll proffer her as an expert and ask you to confirm that she's qualified.
Thank you.
So to start then, I want to look at the agreed upon qualifications in exhibit 77. If you want to follow along on the second page. For the purposes of stage 3 of this case, the parties agree to the expert qualifications of Dr. Barbara Messamore as follows. A historian with expertise in 19th century British, North American, and Canadian political and constitutional history, including the relationship between Great Britain and its British North American colonies and Confederation. As a result of the above areas of expertise, the parties agree that Dr. Messamore is qualified to give opinions on colonial finances in British North America, the events and fiscal concerns motivating Confederation, the passage of the British North America Act 1867, and the subsequent entry into Confederation of other provinces after 1867, the allocation of pre-Confederation debts of the province of Canada, and post-Confederation resolution of disputes therein, the post-Confederation arbitrations between Ontario, Quebec, and the Dominion of Canada to settle excess debt under sections 112 and 142 of the British North America Act 1867 and matters arising therefrom. And finally, how the Crown actors of the day understood the above. As a result of the above areas of expertise, the parties agree that Dr. Messamore is qualified to give the opinions within her area of expertise that are set out in her report. And I'd like to enter that her report then as the next exhibit. All of my friends have a copy, and I believe that it's the report, not the slide deck, it's the report.
Which I have dated August 8th, 2021.
That's correct.
Thank you.
I should note that the report was prepared on August 8, 2021. The electronic version has a later date of 2022 because our paralegals went through to insert new numbers for some of the productions in the footnotes to align with the party's productions. So, but the report was actually written on the 8th of August, 2021. So I'd ask that this
Sorry, so does that mean if I'm using a hard copy, then the numbers don't correspond?
No,
with
you've got the
production?
proper copy.
Okay,
Yeah,
thank you.
Yeah. What we could have done is put on this page, the title page, as updated August 2022, which
Oh.
we didn't, but I just wanted to let you know that if you by chance happen to be using an electronic version and see a different date, you can be assured that the copy that we're introducing today in court is the right copy.
Thank you.
And Your Honor has a copy?
I do.
Good, and I'd like to give a copy then to the witness as well. You recognize that?
Yes, I do.
We'll get to that. Thank you. So this will be Exhibit 78. Now, in preparing for today and reviewing Dr. Messamore's report, I realized that we made an oversight in neglecting to attach the letter of instruction that was provided to Dr. Messamore. Dr. Messamore does include in her report a recitation of the questions that council asked her to address, but the actual letter wasn't included and should have been. So the next thing I'd like to have marked as an exhibit is the letter of instruction. A copy for court and a copy for Your Honor. And my parties and my friends have already been provided with a copy this morning.
Thank you.
So this really should have been part of the report at Exhibit 78, but I think perhaps we should mark it as Exhibit 79.
Thank you. Exhibit 79 then.
Yeah, that's good. Yeah, I was just going to say, maybe we'll get a copy for Professor Messamore as well. All right, then I'd like to dive in to ask Professor Messamore questions to elaborate on the qualifications that we've just, I've read into the record, the qualifications as have been agreed upon between the parties, but I wanted just to elaborate a bit. Professor Messamore. I understand you obtained your PhD in history about 20 years ago from the University of Edinburgh.
That's correct.
And what was your thesis?
My thesis was about the role of the governors general between 1847 and 1878, which spanned Lord Elgin through Lord Dufferin. And the title of it was Biography and Constitutional Evolution.
And I understand you're a full professor at the University of the Fraser Valley,
Yes, I am.
and that's a professor of history.
Yes,
Where is that university located?
in Abbotsford, BC.
And how long have you been a professor there?
I've taught there actually since 1990. I taught as a sessional instructor initially. I left in 1995. I went overseas for a few years and came back, I'm going to say about 2001, and have been teaching there ever since.
And when did you become a full professor?
Kind of recently, I think maybe 2 years ago, I think. Yeah.
Now, your report appends your curriculum vitae, and I understand from your curriculum vitae that you were a visiting professor in Canadian Studies at the University of Silesia in Poland in 2017. Is that
Yes.
right?
Yes, that's correct.
And what did you teach there?
They have a graduate program in American Studies that has a subsection devoted to Canadian Studies. And I taught a course in Canadian Constitutional History and a course in Canadian External Affairs or Canadian Foreign Policy.
I see that you are an elected fellow of the Royal Historical Society, UK. Can you explain to us what that means?
Yeah, the Royal Historical Society is a organization for which membership has to be sponsored and voted upon. And essentially it would admit to membership somebody who has a significant publication record in history.
I see as well that you are a member of the Institute for the Study of the Crown in Canada. Can you explain what that organization is involved in?
Yeah, that organization it's not an advocacy group per se. It is about the study of the Crown in Canada. And it holds periodic conferences, has periodic publications, and is also meant to be kind of an educational site for people. So for example, one of the things that they do is have backgrounders, some of which I've written, that are on the site to explain various aspects of the Crown. So for example, the Crown in government formation, that sort of thing, that kind of explains some of the basics.
And so you've authored backgrounders for that organization?
I have, yeah.
And you've written a number of books on Canadian history. Can you tell us about your book, Canada's Governors General, 1847 to 1878, Biography and Constitutional Evolution? Can you tell us about that book?
Yeah, that book was published by University of Toronto Press, and it was an adaptation of my PhD dissertation. So the title is rather clumsy, I'll acknowledge, but I was trying to use a study of the Office of the Governor General to explain how Canada's constitution has changed. So that period that I deal with embraces confederation, but it also deals with the advent of responsible government or colonial self-government in the 1840s. And one of the things that I guess I've tried to address in the book is the fact that even, excuse me, when structurally things appear the same, there's an evolution in constitutional conventions and usages, and studying the Governor General is kind of a good way to get at that. So it really spans how that relationship, that colonial relationship in a sense, has evolved.
And you've written chapters for textbooks on Canadian history as well. Can you tell us about that?
Yeah, I have two textbook projects, one published by McGraw-Hill Ryerson and the other by University of Toronto Press. And in each instance, I wrote I think 7 of the 12 chapters in the pre-Confederation volume. So that included the 7 Years' War, for example, but it mostly included the later half, the 1830s rebellions, through to the advent of colonial self-government, confederation, and kind of mid-19th century Canadian history.
Thank you. Justice Hennessy, I ask that Professor Messamore be qualified by the court as an expert in 19th century British, North American, and Canadian history, and in particular qualified to give opinion evidence on the topics that are enumerated in the agreed upon statement of qualifications.
Thank you very much. And counsel, I understand that's on consent. I can't really see Ontario. Professor Barbara Messamore is so qualified to give opinions on under that agreed qualification statement. Thank you.
So Professor Messamore, we've talked about your qualifications. I want to talk now about what you are not qualified to opine on.
Sure.
Areas that may be important to this case, but outside of your expertise. So I want to ask you about Indigenous history. Do you have expertise in Indigenous Canadian history?
No, I don't. When I teach Canadian survey courses and Canadian history generally, of course, there has to be consideration of Indigenous newcomer relationships, but that's not a particular area of research that I do.
All right. So what can you tell the court about the Anishinaabe perspectives on the making and implementation of the Robinson Superior Treaty?
I would describe that as not within the mandate of what I was asked to investigate. That I understand others can fill that in, but that's not a question that I engaged with. I have at times reported on things in the context of the report. For example, petitions, where there's a document that's relevant to what I weighed in on, but the particular Anishinaabe perspective is not within my mandate.
It's not within your mandate. Is it within your area of expertise?
No.
Thank you. The other area of expertise is legal matters. You're not a lawyer, is that right?
That is correct. I'm not
And-
a lawyer.
Are you trained at all in the law?
No, I'm not.
Can you explain to the court what it means to you to be a historian?
Okay. Yeah, I think there's a couple of tasks. But I think it is important that when we do research that it's rooted in evidence, that we rely on historical documents in writing history. There's more to it than that. I mean, sometimes people say the documents speak for themselves, but that's not entirely true, that there is a matter of interpretation of opinion that comes into a historical analysis. Context is very important for an historian. To understand a historical document, you need to understand the context in which it was produced. I don't see a historian's role as simply, one thing after another, or something you read in an encyclopedia where it lists events. I mean, that's obviously a historical narrative as part of the task, but it goes beyond that. And what a historian has to do is say what it means. I guess I would also say that those historical judgments are inevitably rooted in our own perspective, that I think the questions we ask of history are very much based upon our current preoccupations and the things that inform us today. So someone writing a history 80 years ago would have asked different questions of that material. But I think fundamentally, you do make judgments, but the judgments must be rooted in evidence.
I think you've touched on this a bit, but can you elaborate to what extent does opinion form part of a historian's work?
Mhm. Yeah, I mean, I think that certainly as an academic historian, you're expected to give your opinion. People might disagree with you. That's okay. That's how it works, right? So I think that the opinion has to be rooted in evidence. You cite your sources so people can see what evidence you've consulted. Informing that, they can go back to that same evidence and perhaps form different ideas based upon it, or may have different ideas based upon it. I think that typically what we have to do is rely both on primary documents, and I've certainly done my share of archival research over the decades in a number of different archives in Canada and Britain and elsewhere. But it's also a good historical judgment will also rely upon secondary sources and what others have said, and you assess those in making historical judgments. Yeah.
So we'll shortly get into the specific questions that you were asked to address in your report, but broadly speaking, can you explain for the court what was the intention of your report?
Well, the intention, kind of as laid out in the instructions, was limited to certain questions. I understand that what I was asked to do is only part of a much bigger picture. I was asked to describe how the framers of the British North America Act dealt with debts and liabilities.
Professor Messamore, I was going to say, we'll get into those specific questions, because we addressed them, I know, in your slide deck, but I meant more generally speaking, what was your intention coming at this report? What did you cover and what did you not cover? What aspects of this case were you not intending to opine on?
Mm-hmm. I wasn't intending to reflect on what ought to have been determined in terms of payment of annuities, share of resource revenue, that sort of thing. The court has ruled on that and will consider that. I suppose the question that frames what I do is for compensation or annuities paid, whether the provincial government of Ontario, the province of Canada, or the Dominion of Canada bears responsibility for increased payments.
Thank you. Have you ever testified as an expert witness before?
No, I have not.
Have you ever testified at all in court?
No.
And have you ever acted as an expert witness?
I did prepare a report in, I think it was 2015, for a British Columbia case involving the Songhees and other First Nations. And the question I was asked to investigate at that time had some overlap with this question insofar as it involved the Dominion assumption of provincial debts and liabilities at the time of Confederation.
And that was with respect to British Columbia's
Correct, yes.
relationship?
Yeah.
To Confederation?
Yeah.
Thank you. All right, and I'd also like to address, before we get into your report and your presentation, I'd like to address methodology.
Mhm.
Can you, I know at page 5 of your report, which I don't think we need to bring up, you discuss your methodology. Can you explain for us what your methodology entailed for the preparation of this report?
Yeah, it is a brief description, I know. Essentially, I would describe it as standard historical methodology where you rely upon both primary and secondary sources. In this case, some of the primary sources were provided to me, many documents, I think something like 3,000 of them, many of them hundreds of pages long. But in addition to that, where I felt that there had to be perhaps additional context offered to inform a particular part of the report, I drew upon other primary sources, and I also drew on secondary sources as well.
So the documents that were provided to you, you said thousands of documents, some of them hundreds of pages long. Who provided them to you and what were they?
Yeah, so these would be primary documents that were provided by the Council for Canada, right?
And they were, I think you mentioned in your report, documents relating to the productions of the parties in this case.
Correct, yes, yeah, from all parties, as I understand it.
Great. All right, so you've summarized your report in a PowerPoint slide deck, and I'd like to, that's already been shared with my friends, and I want to make sure that the court and Your Honor have copies. Got copies of that? Yep, that's it.
Thank you very much.
Thank you.
Professor Messamore, is this a copy of the slide deck that you prepared?
Yes, it is.
And this summarizes your report?
Yes, it does.
All right. Is there any part of this slide deck that you did not prepare yourself?
I had some assistance at the end with the formatting of it, and also the headers and the footers. I had supplied some of the headings myself, but others were added afterward.
All right. So, and in particular, I see we have headers and footers that were added by council to assist in formatting, but the headings themselves, the large bolded headings on each page, did you prepare those?
I prepared some of them, but not all.
All right.
Yeah.
And the reason I wanted to make that clear is I want to take responsibility for the fact that some of these headings have typos and spelling errors, and they do not belong to Dr. Messamore. So, all right.
Forgiven.
It was done fairly quickly. We can mark this as the next exhibit, which would be exhibit 80 if my friends are content. Otherwise, I'm happy to wait until we get through the deck to let my friends make a decision.
I wonder if we might, as with the past practice of our witnesses, mark this as a lettered exhibit until we've had an opportunity to review it and satisfy ourselves that there's nothing new in it.
Certainly. And what letter are we at? Thank you. Exhibit X then.
All right. We'll come back to that.
Thank you.
Just so we have all the documents in front of us, I also prepared a compendium of some of the documents that you quoted from in your slide deck. So I've already shared that with my friends, and I believe that the court and the registrar and the court has a copy, and I hope that you do as well, Justice Hennessy, a copy of the compendium.
It's coming up.
All right.
Thank you.
Thank you.
Now, this compendium I don't propose to mark as an exhibit. It was really prepared by council just to assist, because I noticed that some of the slides have extensive quotes, and I thought it might be helpful to look at have available the source documents. So I selected these myself, and all of them, except the first tab, which is the Constitution, all of them are already exhibits in the joint book of documents. You'll see that in the index.
Unless you object, I would like to make it a lettered exhibit.
That sounds
It's just
to
makes
keep
it
track of it. Yep.
a place where we can go and find it. X, Y.
And the final document that I would like to pass up is a cast of characters. And this document it's called Index to Cast of Characters, but in fact, it's just a cast of characters. This document was prepared by council from Professor Messamore's slides. And Professor Messamore, let me show you a copy of it.
Thank you.
I understand that you have reviewed this cast of characters and are content with its content.
Yes, I have.
All right. And it shows in one of the columns where in your slides you reference these particular individuals.
Yes.
All right. So I think it's really just intended as an aid for counsel in the court as these names come up, and you might want to follow along. So I think it would be helpful to mark this as an exhibit as well. I'm not sure we'll get into it directly, but it's sort of be a cheat sheet as we come up with, and hear about these.
If the witness adopts it, wouldn't it be a good exhibit?
Well, that's what I was saying. I'd like to mark it as an exhibit.
Like a numbered exhibit?
Yes.
Oh, okay. And does anyone object, counsel, is there any objection to marking that now, or do you want to wait until later in the examination?
I would be fine with marking this particular document now as an exhibit, Your Honor.
All right, thank you.
Exhibit 80. All right, thank you.
Exhibit 80, cast of characters. And how do we describe these characters? Are they all Crown actors?
Yes, they are. They're a cast of, well, some of them are counsel for the Crown. Some of them are judges. But
They're
there are
people
no
too.
Indigenous parties.
Politicians.
I'm sorry.
Go ahead.
I'm sorry, I said politicians. I don't know if I should have interrupted.
Some of
at
them
this
are,
point, but yeah, some are politicians.
Characters, Crown, I think it's appropriate to call them Crown actors. Cast of
Historical Crown actors?
historical Crown actors.
What
yeah.
does
I
Ms.
was
Barclay's
just going
up?
to suggest myself historical actors.
Historical actors?
Given that there are judges, I wouldn't call a judge a Crown actor per se.
All right. Cast of historical actors.
Thank you.
How's that? Thank you.
All right, so I think then we can start by going through your slide presentation.
Okay.
All right, starting on page 2, you have your acknowledgement of duty. I don't think we need to go through that. It's clear that you recognize your duty as an expert witness is to assist the court and to do so in an impartial and objective way. So before we get into slide 3, though, I think we need to look at the tab 1 of the compendium, which is relevant provisions of the Constitution. Because we're going to be coming back to these in a lot of the documents, so I think it would be helpful to look at them at the outset. So I would ask you, Dr. Messamore, and the court to turn up tab 1 of the compendium, where we've reproduced certain portions of the Constitution, Constitution Act 1982, and in particular, the provisions that we're interested in begin at 109, and I'll have my friend put 109 on the screen. Because this is particularly relevant to your opinion, I'd ask that you read out section 109 for the court.
Section 109 reads, all lands, mines, minerals, and royalties belonging to the several provinces of Canada, Nova Scotia, and New Brunswick at the Union and all sums then due or payable for such lands, mines, minerals, or royalties shall belong to the several provinces of Ontario, Quebec, Nova Scotia, New Brunswick, in which the same are situate or arise, subject to any trusts existing in respect thereof, and to any interest other than that of the province in the same.
Thank you. And then turning the page, there are two other relevant provisions,
Mhm.
sections 111 and 112, and I'd ask if you could read those for us as well.
Yes, section 111 reads, Canada shall be liable for the debts and liabilities of each province existing at the Union. And section 112 reads, Ontario and Quebec conjointly shall be liable to Canada for the amount, if any, by which the debt of the province of Canada exceeds at the Union $62,500,000 and shall be charged with interest at the rate of 5% per annum thereon.
Thank you.
Would you mind asking this witness if she would give me what, if you were just speaking to another constitutional historian,
Uh-huh.
what your short form for each of these would be?
Okay.
Because we may
Uh-huh.
end up referencing that. I'd like to know how you would shorten it.
Okay. I guess for section 109, I would say that this was the description of the fact that, you know, at Confederation time, different areas of jurisdiction were placed under the control of the Dominion government or the provinces. And in this case, this placed 109 placed under the control of the province's natural resources.
So jurisdiction of natural resources went to the provinces at Confederation.
Correct.
That's
Yeah. That's how I would say it. Yes.
and that's how you understand it.
Yes, it is.
Okay,
Can-
thank you.
Can
Or,
I
sorry, go ahead.
interject?
Yeah.
When we talk about jurisdiction, there's
Ah.
such a thing as legislative jurisdiction.
Okay.
And is section 109 speaking about legislative jurisdiction or something else?
I would say, I can't speak to the term, well, I guess what I would say is that it's talking about, I guess what we broadly called ownership, but a
Thank you.
qualified ownership.
Okay.
And with respect to Your Honor's question, section 111, both 111 and 112 speak to the question of the financial arrangements made at the time of Confederation, that the Dominion government assumed control or assumed responsibility for the debts and liabilities of each province, but each province was understood to have a debt ceiling, a debt allowance that over which they would have responsibility for further debt. So,
The provinces.
sorry, the provinces, yeah.
So
So,
so could we say that Dominion assumed debt and liability of the provinces up to a maximum of $62,500? Would that
yes,
be
in a sense, that's true. I
I
mean,
should just
in-
interject to say
yeah.
that the amount was actually 62,500,000.
I'm sorry,
What did I say?
I missed that. Yeah, I missed that. Yeah. So,
That would be
so
bad.
yes, in point of fact, the Dominion assumed more debt than that, but it was understood that when they did so, that the provinces would be responsible for paying interest on debt that exceeded that debt ceiling, that $62,500,000.
Okay, thank you.
And in fact, section 112 says Ontario and Quebec conjointly shall be liable to Canada for the amount, if any, by which the debt exceeds that amount and shall be charged interest. So does this then suggest Ontario and Quebec are liable for the full amount, even if they're only charged interest on it?
Yes.
Thank you.
So is another way to say it, and I don't mean to get into
No, I
your
understand. Yeah.
interpretations at another point. The
Mhm.
Dominion assumed debt and liability of provinces to a maximum of 62.5 million and debt in excess of that with interest of a rate of, subject to the obligation the provinces to repay that.
Yes, that would be accurate.
Going then to the questions you were asked to opine on, Professor Messamore, which you've set out starting at page 3 of your slides. Maybe you can go through those first 3 questions for us.
Mhm. Okay, so my review of the historical record seeks to shed light on, 1, how did the framers of the British North America Act make provision to deal with the debts of the province of Canada at Confederation? To what types of debts and liabilities, section 111, and debts, as referred to in section 112, were the framers referring? 2, with reference to the historical record, would the framers of the British North America Act have considered the payment of annuities in the form of a share of Crown resource revenues from the surrendered lands in the years prior to Confederation a debt of the province of Canada? If not, who would the framers have understood to be responsible for satisfying any deficiency in annuities in the years that predated Confederation? 3, with reference to the historical record, would the framers of the British North America Act have considered the payment of a share of Crown resource revenues to the First Nations in the years after Confederation a debt of the province of Canada? If not, who would the framers have understood to be responsible for satisfying any deficiency in annuities in the years following Confederation? Number 4.
Number 4, I'd say
Yeah,
we've already
okay,
gone through that.
Right, so we
Section
have, yeah.
109 is reproduced,
Yeah.
which is what you talked about as the provision respecting ownership of
Mhm.
resources,
Yeah.
natural resources.
Yeah.
And then maybe you can go through then what the particular questions were at the bottom of that slide.
So with respect to question 4, I was asked, how did the framers of the BNA Act understand the word trusts and phrase other interests other than that of the province in the same in section 109? And then 5, in light of the above question, would the requirement to pay a share of Crown resource revenues in the years after Confederation have been understood by the framers of the British North America Act as a trust or an interest other than that of the province, as those terms are used in section 109 of the Act?
And moving then to slide 5.
So the testimony I will provide based on my report will examine in detail the arrangements made at the time of Confederation for debts and liabilities, the arrangements made subsequently for the admission of other provinces, the allocation of the pre-Confederation debts of the province of Canada, and post-Confederation arbitrations between Ontario, Quebec, and the Dominion of Canada to settle excess debt under sections 112 and 142 of the British North America Act. I'm sorry, there's a typo there. It should say 1867. I think that typo was mine. And matters arising therefrom.
All right, and we haven't yet looked at section 142 of the BNA Act, but we'll get to that, right?
Yes.
All right, so at slide 6, you go through an overview of your opinions.
Yes,
you
I
please
do.
do
Yeah.
that?
I feel like perhaps this is my training as an academic historian, that I think what generally makes sense, how we would do things, would be to, based upon the research that we've done, articulate essentially a thesis at the beginning to lay out what conclusion I've come to in this case, and then provide the evidence to show how I've reached that conclusion. And so I've sought to do it that way, to put an overview of my opinions at the outset. And the first one being that the payment of any additional amounts for annuities in the form of a share of Crown resource revenues from the surrendered lands arising from the years prior to Confederation would have been considered an obligation of the province of Canada.
Can I stop you there? When you say
Yeah.
would have been considered by whom?
My thinking here is I'm thinking in terms of the framers of Confederation and how they would have viewed it in the context of what they were doing.
Thank you. And then slide 7.
And can we assume that you are always speaking about the framers? I see that's in your questions and your issues.
Yes, I suppose that, I guess generally speaking, yes, that is sort of the question that I was asked to address is how the framers would have understood it. So I think that's the basic
Okay,
question informing it, yeah.
thank you.
Slide 7 then?
And sorry, secondly, my opinion, the payment of any share of Crown resource revenues due to the First Nations arising from the years after Confederation, based on my analysis of the historical context and record, would be considered the responsibility of the province of Ontario alone. And questions 4 and 5.
Now we're on slide
Oh, and sorry,
8.
slide 8, yes, of course. Deal with the issue of trusts or interests other than those of the province that might.
I'm just going to warn you,
Yeah.
if you read,
Yeah,
you will notice that you speak much more quickly than if you were speaking.
okay.
So although we have fancy reporting here,
Oh, too
Um,
fast.
we also have some handwork to be done. I'm also making notes.
Ah,
And I really want to integrate what you're saying because I may have questions from time to time.
of course, of
Thank you.
course, yeah. So with the questions 4 and 5, dealing with the question of trusts or interests, other than those of the province that might exist with respect to lands, mines, minerals, and royalties belonging to the provinces in which these are situated. I've said in this case that this is not a question upon which I feel qualified to render an opinion. The question of whether or not the claims of treaty participants constitute a trust has been the subject of earlier court cases. And I think that this is a matter in which I don't have the legal expertise to assess that matter. I have in my report at times reported on what others have said, but I have not rendered an opinion about whether it ought to have been considered a trust.
Thank you. I think then we can move to slide 9, which is principles you have drawn from your research.
Yeah, I think there are a couple of important principles underlying what I have concluded. One is that the framers of the BNA Act, the framers of the Confederation Agreement, intended to apply a clearly defined, limited, and specific ceiling to the amount of provincial debt for which the Dominion government assumed responsibility. We've addressed this point already, but I'll mention it again. If debt assumed by the Dominion exceeded that ceiling, the province would be liable to the Dominion for that excess and was required to pay interest on the excess amount at 5%. And another principle, and for this, I will get into this, I think, but since early in the pre-Confederation era, the principle had been established that costs would be assumed by the government that enjoyed the revenues.
Can I have that proposition again?
Yeah, certainly. Since early in the pre-Confederation era, the principle had been established that costs would be assumed by the government that enjoyed the revenues, that costs and revenues were always considered in tandem, were always assumed in tandem.
And I notice in these slides, there's not necessarily a paragraph reference to the report.
The in this, some of these slides I understand are summaries of your opinions, and you don't necessarily include where in your report you address these particular opinions.
Oh,
but
okay, yes.
I
yeah.
do note that we'll come to it when you recite facts,
Right.
relying on documents, then you do have the report pages.
Yeah, I believe that beginning on page 12 and consistently throughout the whole rest of the report, there's always at the top a page number referring to where in the report this came from. I didn't do that with the opening slides, I guess, because I saw them more in the way of overview of its entirety. That was kind of my thinking there.
Thank you very much.
Yeah.
All right, so slide 10 is something we may come back to because it's an outline, sort of a summary of the topics that you deal with, this historical outline. And I was going to ask you those numbers in square brackets beside each topic, what do those numbers refer to?
Those numbers refer to the pages in the report.
All right. So let's get started then. The first topic is pre-Confederation era context and general principles informing finances.
Mhm.
And I think that takes us to slide 12. Can you take us through the early British regime?
Yes. So of course, Quebec, Canada came under British control after the 7 Years' War in 1763 with the Treaty of Paris. And what I've dealt with in this first early section of the report were initial British plans for governance of that new territory. And there's kind of three phases I address here. The first one is 1763 Royal Proclamation. The second one would be the 1774 Quebec Act, and the third one would be the 1791 Constitutional Act. So these, in essence, are three British plans for governing this new territory that after 1763 was known as Quebec. So Britain planned initially and laid out this plan in the Royal Proclamation of 1763 to introduce elected assemblies into the new British colony of Quebec. Copying, and I quote here from the Royal Proclamation, other colonies and provinces in America which are under our immediate government. Sometimes this has been called government by analogy. It was essentially modeled broadly on the British system, but more specifically on what was already in place in the other British colonies that would later become the United States. So the salient point being that there would be elected assemblies introduced according to this plan in 1763. That did not prove to be practical in Quebec. And that was because the residents were predominantly Roman Catholic and few would be eligible to vote or to stand for election.
Because they were Roman Catholic.
Because they were Roman Catholic.
So slide 13.
Yes, please. Yeah. And so this raised the difficulty of how revenue would be raised because the principle was that elected assemblies would be able to vote funds. So there had to be some other means for funds to be raised for support of the colony in the absence of an elected assembly. So the 1774 Quebec Act, well, we kind of recognize it now for different reasons. We think of it as this first statutory recognition of the distinct nature of Quebec society. But in this context, what's important about it is that it was a retreat from the plan of representative government. And I might say there that this is one of the reasons, I suppose, that it's important to read documents in context, because it doesn't address the question of elected assemblies. It's important, I suppose, to read what isn't in the document as much as what's in it. So it really represented a retreat from the plan of representative government.
Can I interrupt to ask
Yes.
you, what does it mean to vote funds?
It means that the elected assembly would pass a supply vote to meet the financial needs of the colony.
And what is a supply vote?
I'm sorry, they vote for costs associated with that colony.
As I
allocate.
understand from your point here, is it to raise
Oh,
funds?
I'm sorry, to allocate spending in the, essentially like a budget vote, you might say, yeah.
So as I understood it, when I read it, it was to spend funds. Does it presume there are funds?
Well, that would be this, I guess, the second part of the role of the elected assembly. They might impose local taxation. There would be also, I get into this a little bit in later in the report, additional funds available through Crown revenues. So
Okay.
yeah, so it would be one source of funding might be local taxation.
Thank you.
Thank you. That actually was the point I was
I'm sorry, yeah. I
trying to
didn't
get
make
at.
that clear.
You're
Yeah,
you're talking here about taxation.
right. And I'm sorry if we could just move back to slide 13 for a moment. One important point that I didn't specifically say here is that in Quebec then, with no elected assemblies to supply a vote for revenue, revenue to support the colony was raised by means of the 1774 Quebec Revenue Act. And this was British legislation that provided for duties on certain imports and differentiated duties based on the origin of those goods. And that taxation base would be used to support the colony, to defray the expenses of the colony.
Okay, thanks.
So, and it was called the,
Quebec Revenue Act. Yeah,
Of the
passed
same year.
Same year as the Quebec Act, yes. Yeah, so I think they're kind of best seen in tandem, that it's recognized that the assembly would not, there would be no assembly to vote to impose local taxation. The money would have to come from somewhere. It would come from tariffs imposed by the British government.
I think we can then move to slide 14.
Yes, my caption here is the British articulated some principles about taxation amid the American Revolution. That, of course, broke out in the spring of 1775. The particular act I mention here is the 1778 Colonial Tax Repeal Act. And it, in the context of the American Revolution, sought to, quote, remove all doubts and apprehensions concerning taxation by the Parliament of Great Britain in the North American colonies. And essentially, the Colonial Tax Repeal Act declared that British tariffs were for the purposes of regulating trade. And the more important point here, I think, is that the net produce of such duties, quote, was always to be paid and applied to and for the use of the colony, province, or plantation in which the same shall be respectively levied. So the idea there being that Britain was not imposing taxes that were flowing into the British coffers. They were imposing taxes that would be applied for the use of the colony itself.
I
Sorry.
noticed here you have in square brackets F and 8. Can you just clarify? if that's a
Yes,
reference to a
that means
footnote?
footnote, correct.
And that's a
Yeah.
footnote in your
Footnote
report.
in my report, yeah,
And this particular quote here, is this an actual quote from the?
from the legislation itself, from the 1778 Colonial
I'm
Tax
just gonna-
Repeal Act.
I'm just gonna ask you to let each other finish.
Oh, I'm
Sure,
sorry.
It's okay. It's hard to
Sorry.
get it down.
Is there anything else you wanted to address on slide 14?
Yeah, so on this slide, similarly, taxes raised by the local assemblies for those colonies that had local assemblies, which didn't yet include Quebec, would also be used for local purposes. And on slide 15 then, the third phase in Britain's plan for governance of Quebec was in fact in 1791 to divide Quebec into two provinces, Upper and Lower Canada. And this act is significant because we had representative government, elected assemblies implemented for the first time with the 1791 Constitutional Act in each of those two colonies. In terms
On
of
slide 16.
Oh, I'm sorry, slide 16. Yeah. In terms of finance, the Constitutional Act in section 46 repeated essential elements of the 1778 Colonial Tax Repeal Act. And that was the principle that Britain retained the right to impose tariffs to regulate trade. And again, I'm quoting from the act itself, the net produce of such duties to be always paid and applied to and for the use of the colony.
And then slide 17.
Yes, so the Constitutional Act, this is also discussing the new regime under the Constitutional Act. I've said that the elected assembly had the power of the purse, that is control over money bills and local taxation. But there were separate revenues, the proceeds of certain taxes that were controlled by the crown. And examples of that include proceeds from the duties imposed through the 1774 Quebec Revenue Act and other revenues such as those arising from fines, seizures, and forfeitures.
And when you say controlled by the crown at this point in 1791, that's controlled by the imperial crown.
Yeah, what I mean by that specifically in the context of the colony would be the British appointed Governor General.
So that's why I asked the question. Was the Governor General considered the imperial crown?
He was, yeah, so he was the representative of the crown. And his position, I suppose part of the reason I've chosen to specialize in that is because I find it a very interesting office, that I think you can see all the tensions in the role, that he is appointed by the British cabinet. And yet he serves in Canada and carries out his duties. I mean, especially after we have the advent of responsible government in 1847, he's essentially simultaneously accepting advice from two sets of ministers. He has the British cabinet, and then essentially in the era after the advent of responsible government in 1848, he's also acting on the advice of Canadian ministers. Does that?
Well,
No.
it does help.
Yeah.
It's very helpful. But what does it actually mean in this statement, controlled by the crown?
Okay.
Does that mean the Governor General had powers independent of the elected assembly?
Yes, it does. Yeah, that's what it means. So I think in terms of finance, that was a matter of contention for the colonies themselves, that they felt that they, as long as there was an independent source of revenue that didn't rely on the consent of the assembly, then they really were not, they didn't enjoy control themselves over the important matters of spending. So the governor had no need necessarily to summon the assembly to meet if he enjoyed on a regular basis, if he enjoyed access to a budget beyond their power to vote, if that makes sense.
Well, if he had some revenue.
Correct, yes.
And presumably that was not the revenue that the colonial government had access to, that had just been, I don't know if the word is allocated or provided to them through the Tax Repeal Act, the Colonial Tax Repeal Act.
Yeah, so that was, there were a number of sources of this crown revenue.
Okay.
One of them being some specific British legislation that, yeah, I think the sort of most important point is that he did have access to funds that did not require the consent of the assembly from various sources. Not perhaps sufficient revenue, but some revenue.
Thank you.
Yeah.
And is it, if I can ask,
Mhm.
and I apologize if this is leading, but just following up on the Justice Hennessy's questions. So if the Governor General had control of revenues, in tandem with that, I expect then he had control of spending, and this may be, is that correct?
Yes, there was some spending that was kind of baked in, you might say. There was a civil list of certain certain expenses that would be paid.
But we'll get
Yeah,
to the
sorry,
solicit.
yeah,
So
okay, yeah.
essentially, it looks like there's two purses, really. One collected by the legislative assemblies in the colony through direct taxation, and then spent according to their votes. Is that correct?
Yes, that's correct.
And then the second purse is money that the Governor General had access to directly from the Imperial Crown. Is that
Uh,
correct?
Yes, I think that's a good way to envisage it. Two purses would be a good analogy.
Thank you.
All right, are we then ready to go to slide 18?
Yes, I think so.
You were about to tell us about the civil list.
Yes, so in slide 18, the revenues controlled by the Crown, and I say here in practice, the British appointed governors, were used to support a civil list. The civil list was made up of non-military colonial costs, and that included costs for the administration of justice and civil government, including official salaries. Crown revenues covered part of the civil list, but an annual vote of the elected legislature was also necessary to cover colonial costs.
And here, when you talk about the elected legislature, you're talking about in the colony.
In the colony
colonies.
itself, yes.
So the point you're making is that this civil list was covered in part by this money that was controlled by the British appointed governors,
Yes,
and in part by funds raised by the elected legislative assembly in the colony.
yes. So the civil list is some fixed costs. It's not all the costs, of course, right? So just as we'd say there's two purses, there's also, in a sense, two sources of expenditure, right? One of them, the fixed civil list costs.
For the
And-
administration of the colony.
Correct, yeah.
Slide 19, I think, goes on to explain more about the civil list.
Yes, and so I've said from early in the 19th century, the British government sought to have the British North American colonies assume responsibility for covering the civil list costs through permanent colonial legislation as distinct from British legislation. And yeah, so in slide 20, I've just used the example of during the War of 1812, a case could be made that it was in British interest to lend direct financial support to its British North American colonies, but the case was harder to make in peacetime. So essentially this section of my report kind of deals with the increasing British pressure in the 19th century to enforce the principle that colonies should be self-supporting, that their expenses should be met by revenues raised in the colony itself. And I think if there was an exception to that case, there would have to be kind of a reason for that exception. And that's why I raised the issue of the War of 1812, you know, a war that was partly about Canada, but not entirely about Canada. It was, of course, the British at war with the Americans, and Canadians might make the case, well, this isn't entirely our quarrel, I suppose, is an important point there.
Can we move into slide
Yes.
21?
Okay, so complicated finances of Upper and Lower Canada. So it's introducing a further complication at this point. The complication is that customs revenue, that was the lion's share of the revenue that the colonies depended on, Upper and Lower Canada, was collected at the main St. Lawrence ports of Quebec and Montreal. Those imports were destined for both colonies. So a portion of the revenue had to be paid by Lower Canada to Upper Canada on the principle that a portion of those goods were destined for Upper Canada. Lower Canadian reformers sometimes use the obstructionist tactic of refusing to pass essential financial measures as a means to try to force political reform. And one of the things the British hoped to do to get around that was to combine the colonies of Upper and Lower Canada into one. They had a plan in 1822 to unite the two colonies, hoping that that would help to redress the that difficulty. I described it as an abortive plan because the bill was not in fact passed in 1822.
So moving to slide 22.
Yes, so in 1831, the Canada Revenue Control Act, it was a piece of British legislation, was drafted by Lord Howick. And I mentioned that Lord Howick was later the third Earl Grey. And that's kind of important, I think, because as Secretary of State for the colonies in the 1840s, Earl Grey would be the one who would oversee Canada's transition to colonial self-government.
And here we're talking about the province of Canada.
I'm sorry, yes, the province of Canada, yes.
And that's throughout this slide.
Um,
And the next, it's the province of Canada.
Well, in in this particular slide, I'm just getting ahead of myself there because when I referred to Lord Grey's policy of introducing colonial self-government, that would have been after the Union of 1840. And so the period I'm talking about here now in 1831 was before that. So that would have been while there were still two separate colonies, Upper Canada and Lower Canada in 1791. And so this 1831 measure, I mentioned Lord Howick because I think it's indicative of his mindset in terms of the relationship of the British government to its colonial possessions in British North America. That as Lord Grey later, he would really push for a policy of granting greater autonomy to those colonies, and going along with that, a policy of wanting the colonies to be as self-supporting as possible. But I think we can see inklings of that thinking as early as his earlier role in 1831, drafting this Canada Revenue Control Act. It surrendered control over the Crown revenues to Canada, and they hoped that in turn, British authorities hoped in turn that the Canadian colonies, Upper and Lower Canada, would respond by voting a permanent civil list, that they would agree to having a Canadian piece of legislation that would provide for a permanent civil list for these fixed costs. In other words, Britain's colonial office hoped that with Canada granted control over the revenues, they would take permanent responsibility for fixed costs.
Could I
Yes.
ask then if it's not called the province of Canada until 1840?
Correct, yeah.
So in 1831, what does the Canada Revenue Control Act?
That would have
refer to?
referred to Upper Canada and Lower Canada.
Oh, just to both of them, but they're not united yet.
Correct.
So we could have said, they could have said Canada's.
Yes, yes. Yeah, in fact,
Okay.
they use that phrase quite a lot, the Canadas. Yeah.
Oh, okay.
Yeah.
Can we continue then to slide 23?
Yes. In the wake of this measure by Britain in 1831, Upper Canada obliged with a permanent civil list, but Lower Canada declined to do so because of the potential to use the annual vote for the civil list as an opportunity for leverage in the quest to gain other reforms. Now we move on slide 24 to the Union Act. I've skipped over the rebellions of 1837-38, which aren't really relevant to my purposes here, but the important part of it is that Upper and Lower Canada were united as a single province of Canada through the 1840 Act of Union, through this British piece of legislation.
And that takes us to slide 25.
Yes. Lord Durham, who had been appointed as Commissioner and Governor General to Canada in the 1830s in the wake of the rebellion, had issued his report on the affairs of British North America and had made the recommendation for union. Durham's sometimes blamed for this, but in fact, he didn't recommend this. The idea of a single legislature granting equal representation to each district of the United Colony. So under the Act of Union, we had a single colony with one legislature, but representation was divided in half, equal number of seats for Canada East and Canada West.
So here we've changed from Lower Canada and Upper Canada to Canada East and Canada West.
Correct, but those are just districts within a single colony. And I just mentioned that Durham, in fact, had specifically warned against any sort of monkeying with the legislation to try to, or sorry, with the representation to try to make it unfair to Canada East.
You want to preserve his reputation.
Well, perhaps, or at least he's blamed for plenty and has plenty to answer for, but not that.
All right, can we move to 26?
Yes, the Act of Union, like the 1791 Constitutional Act, reiterated the principle that Britain retained the right, as set out in the 1778 Colonial Tax Repeal Act, to regulate commerce through tariffs. And it, again, quoting from the Act of Union itself, provided always that the net produce of all duties which shall be so imposed shall at all times hereafter be applied to and for the use of the said province of Canada. So in this case, although we're referring now to the province of Canada, this principle is retained, it's remained, I should say, consistent throughout. That really from the 18th century, the idea being that the net produce of revenues raised are going to be applied to and used for that colony.
For the colony that raised them,
Yes, correct.
or from which they were raised.
Yes.
And would you say now that produce can be replaced with what word? Revenue?
Revenue, certainly, yeah.
Slide 27?
With the Act of Union, the finances of the once separate colonies were consolidated, commingling Upper Canada's debt with Lower Canada's surplus. The duties and revenues over which the legislature had control would form a consolidated revenue fund, which would be charged with all the costs related to its collection and management.
And then I see on the next slide, slide 28, you have reproduced a provision from the Act of Union, which I don't think it's necessary to read for us, but I see it refers to Schedules A and B, which you deal with on the next slide. So can we maybe go to slide 29?
Yeah, so Schedules A and B appended to the Act of Union laid out the costs that came under this, costs such as salaries for the governor, judges, civil servants, pensions, and related expenses. Although they were later found to have overlooked some important ongoing costs, among them the ongoing annuities to First Nations that had arisen from treaties. And I should just remind the court that this was prior to the Robinson treaties. This was in 1840, so other treaty annuities and things had not actually been listed in the civil list costs, the permanent costs.
And so,
But can I sort of, I'd like to go back to slide 26 if I can. So the union, your evidence was that you said, although we're referring now to the province of Canada,
Yes.
this principle is retained. And you say remain consistent. The idea that net produce or revenues raised apply to and are used for the colony.
Yes. Yes. So this principle really from the time of the 1778 British Act, the Colonial Tax Repeal Act, laid out the principle that, yes, Britain retained the right to impose tariffs. And in fact, that was something that Canada only incrementally, gradually gained control over in the post-Confederation era, in fact. Britain retained the right to impose tariffs, but Canada.
But didn't repatriate them to the UK. They
correct.
imposed the right to impose, but not to keep.
Yeah, so it was understood that the tariffs raised within the colonies would be used for the benefit of the colonies, yes. And so I guess to me, it seemed important to mention this because we have this principle being laid out in the pre-Confederation era in the 18th century, but then we've had constitutional changes since then. So for example, the 1791 Constitutional Act, the 1840 Act of Union. And I guess the point that I wanted to underline here is that that principle was retained throughout all those constitutional changes, and it was specifically articulated in the legislation in each case.
Thank you. Sorry, go ahead.
No, that's fine. I think we had left off, you were on slide 29 telling us that the civil list,
Yes.
which was intended to cover permanent fixed costs, as
Mhm.
Justice Hennessy suggested, sort of administrative costs of the colony might be one way to look at them, was found to have overlooked important costs, including some ongoing annuity payments to First Nations. I think that's where we left off. Can we move to slide 30?
Certainly. So at the time of the Union, there was some correspondence between the outgoing Upper Canada Lieutenant Governor Sir George Arthur and the Governor General Lord Sydenham. That's also Charles Poulett Thompson, Lord Sydenham. I think I've referred to him where I have referred to him as Sydenham, but I should make it clear that's the same person. So of course, with the Union, we have Sir George Arthur's position as a separate lieutenant governor of a separate colony being eliminated. And they corresponded about pending financial matters at the time of Union. So on November 30th, 1840, for example, Sir George Arthur wrote to Sydenham to say the Chippewa Indians who've made a large surrender to government of lands called the Saugeen Tract were much dissatisfied at not having yet received a fixed annuity for the cession and understood you to concur with me that some arrangement should be made for them. Can we move to the next slide? On 31 then, slide 31, Sydenham replied a week later to agree that it was an equitable arrangement that a per person annuity should be paid as had been done in similar circumstances. And Sydenham went on to say to Sir George Arthur, it will of course be understood that the annual payment to the Indians is to be a charge on the land.
Just to slow
I'm
down a
sorry.
bit while you recite this.
Slow down a bit, sorry. It will be, of course, understood that the annual payment, is it okay, to the Indians is to be a charge on the lands, and as the land revenue of the Crown will be placed at the disposal of the province during the existence of the arrangement made under the Act of Union for the civil list, this charge must be transferred with it and be borne by the land revenue generally.
So what does this mean?
What I
Practically.
think it means is what's happening here is Sydenham and Arthur wish to make sure that the obligations are understood, that they are indeed permanently provided for, that the actual costs will be accurately calculated. But it
the
also-
cost, you mean, of the annuities?
Yes, well, indeed, of all costs. This was just
Okay.
one matter over which they corresponded. There were a number. But I think it also to me, seemed a significant thing to quote in the report insofar as it reflects this understanding that seems to come up repeatedly, that revenues and costs would be transferred in tandem, that these are related.
And can you explain for us how in this passage, what is being related here? Revenues from where? And costs for
Revenues
what?
from the land surrendered. I believe they put it placed at the disposal of the province. There will be revenues from that land, and the charge, the annuities relating to that agreement would have to also be transferred.
And here, just as a reminder, we're not talking about the Robinson treaties here.
No, then this predates the Robinson treaties.
And can I just double check? Sydenham when he answers this letter is the Governor General?
Correct, yes.
And I'm just going to catch up, please. And I'm just going back to this assertion of yours to make sure I have it right,
Mhm.
that this correspondence, in your view, reflects an understanding that you say comes up repeatedly, that revenues and costs would be transferred in tandem.
Yes. And I think that there are a couple of examples later in the report that will discuss that same thing. This is a comparatively early one. But yeah, I think generally the idea that costs and revenues are linked in this way is an important point.
Thank you.
We're coming up to the time for the break. I think we can fit a couple of more slides in. So can we move on then to slide 32?
Yeah, so the next major constitutionally significant development is that in the 1840s, Britain extended internal self-government or responsible government to the North American colonies with elected assemblies, those that had elected assemblies, beginning with Nova Scotia in early 1848 and Canada soon afterwards. This is, I think, important to note because there's not any new legislation marking this, nothing new. I've talked about the various iterations of British government and the Act of Union in 1840. But this is a very important change, and yet it's not a structural change. The Constitution looks the same, but it's going to function in a different way. And I think going along with this, as we'll see, is sort of an expectation that as the colony of Province of Canada now enjoys self-government, they would also be expected to assume a greater share of costs over certain matters.
Can we go to slide 33?
Yes, so I've said, as part of this trend toward greater colonial autonomy, Britain's colonial office, now under the headship of the third Earl Grey, that was the person I referred to as Lord Howitt earlier, agreed that Britain would repeal the civil list provisions of the 1840 Act of Union, which of course was British legislation, permitting the colony of Canada to enact its own civil list legislation. And that act, the Provinces Act for granting a civil list to Her Majesty, received royal assent on the 16th of August, 1847.
I think the next slide, slide 34, might be the last slide to go through before we take a break here. It's still following up on the civil list. Can you take us through slide 34?
And just before we get there, the words permitting Colony of Canada to enact its own civil list That's its own, as you said earlier to Ms. Evans, its own budget legislation,
Yes,
its own spending legislation.
yeah, for permanent spending, I think would be a good
permanent spending.
qualification to
Thank you.
put on that. Yes. Things that
Thank
they're
you.
going to agree on an ongoing basis to spend for. Yeah.
Thank you.
So slide 34.
Yeah, and Schedules A and B of the Act for granting civil list to Her Majesty set out the costs that would make up the province's permanent civil list, including official salaries for the governor, for judges, the cost of pensions and administrative civil service costs, and a line item for Indian annuities was included at £6,666.
So do you know what specific annuities were referred to?
No, I haven't investigated that particular question. It's safe to say, of course, that they were not the Robinson Treaty annuities since those had not yet arisen, but yeah, I don't know what specific ones that came under.
And,
Um,
am I right in understanding then that this is relevant because previously Indian annuities had been overlooked?
Well, overlooked in terms of being provided for permanently in the civil list, yeah.
And now with these schedules to the provinces, or the Province of Canada's Act granting a civil list, at least some Indian annuities were included as a permanent
Correct,
charge.
yes.
And the name of the act is at the bottom of slide 33.
Yes, I believe so. The Act for granting a civil list to Her Majesty.
That's what-
Sorry, is it, yeah. Yeah,
that's what it's called.
yeah, I think so, yeah.
I think that would be a good time to break. We've now reached 10:30, so
Thank you.
I might suggest a 15-minute break if that works for people.
Just to make sure I understand this, you say this is relevant because Indian annuities had not been included as a permanent charge in the civil list up to this time?
Well, this was something that I felt was important to mention insofar as the new civil list.
I'm
did-
just saying, did I get that correct? What you said is important to mention. Did I get that assertion
I'm sorry,
correct?
Your Honor, could you repeat?
I think you said this is relevant because Indian annuities had not been included as a permanent charge in the civil list up to this time?
Yes.
Okay. Thank you. Let's take a break, 15.
All right. We'll recess for 15 minutes. School members, you may be seated.
I think we'll pick up where we left off. We were on slide 35.
Okay. All right, so as I recall, we left off talking about Britain's concession of colonial self-government to Canada and indeed to Nova Scotia also, that came to fruition by 1848. I've said Britain's willingness to concede self-government to its North American settlement colonies with elected assemblies was associated with a shift in trade policy. And this is, I mention this because it's context for this decision that the old mercantilist system of regulatory tariffs was giving way to a laissez-faire policy. Tariffs that had given protection to colonial products in the British marketplace were being dismantled in favor of free trade. In light of this, British parliamentarians were scrutinizing the costs associated with their colonial possessions more closely, and the goal was to devolve more responsibilities onto the colonies themselves, more costs. And one of the most important was responsibility for defense. I also mentioned in passing that we could see the later 1860 decision to place responsibility for Indian affairs in the hands of Canada's local legislature as a kind of a later manifestation of that trend. Slide 36. Lord Grey, as I mentioned, Earl Grey, was the Secretary of State for the colonies who oversaw this important transition. And his correspondence with Lord Elgin is really an important guideline to how those decisions took place. Their personal correspondence, along with some official dispatches, has been published in 4 volumes, and you can sort of see how the process of decision happens through the course of these letters. He, in 1851, advised Lord Elgin, the Governor General, of a general desire in Britain to place, quote, the fiscal relations of the mother country and colony on a footing adapted to the greatly altered circumstances of the present time, as compared to those under which the existing arrangement of those relations has grown up. He wanted to enforce that principle and reinforce that principle that costs should be assumed by the colonies themselves when they enjoyed the benefits. He said, now that Canada, along with the other British North American colonies, quote, enjoyed the advantage of self-government in all that relates to her internal affairs, it appears to Her Majesty's government that this advantage ought to carry with it corresponding responsibilities. And the time has now come when the people of Canada must be called upon to take upon themselves a larger share than they have hitherto done of expenses which are incurred on this account and for their advantage.
I'll just note that this was the one document that I had included in the compendium at tab 2. I don't think we need to pull it up, but if anyone would like to see that in the context of the letter, it's there at tab 2.
Yeah, my thinking was in putting sometimes quotations within the slide that we would have the document available, but it seemed, rather than spending time hunting for it in the moment, that if I pulled out the part that was relevant and put it in the slide, it would be easier to navigate.
Can we move to slide 37 then?
Yeah, slide 37. I've also said that even though he was getting this message from Britain's colonial office about Canada picking up costs that they ought to be responsible for, he occasionally acted as an advocate for the province of Canada when he believed they were being unfairly saddled with costs that weren't of their making. And one example I've written a bit about in a publication is that he successfully won British compensation for the colony because they had been constitutionally unable to legislate to regulate the arrival of impoverished Irish famine migrants to their shores. But then they, as a local colony, had to bear the cost of relief for those who, as they put it, became a public charge. So that was one example. And
So,
this-
sorry, so Lord Elgin was the Governor General.
Correct, yeah.
Lord Grey was,
The Secretary of State for the colonies, and I think at times I refer to him as the Colonial Secretary, which is sort of the colloquial way of referring to that role in the British cabinet.
so was the Colonial Secretary suggesting that the province of Canada bear more costs?
Yes, yes. So
Why?
So he's a member.
The colonial
So-
secretary, sorry.
I'm sorry, yeah. So the Secretary of State for the colonies as a member of Britain's cabinet.
So these
was-
are both UK officials as
Oh.
between themselves.
Well, Lord Elgin is a British appointee in Canada as Governor General. Lord Grey, I'm sorry, did I say Lord Elgin
you
is
did.
the governor? I did, okay. Make sure I didn't misspeak. So Lord Elgin is the Governor General. He is, broadly speaking, a British official, yes. But he also, and this is kind of a point I wanted to underline, at times is advocating for Canadian interests too, that he's on the scene, he knows the Canadian reality. And so he would at times almost intervene on behalf of his Canadian government with the authorities back at home. And I can see this in the correspondence with Lord Grey, the Secretary of State for the colonies.
And just to be
Um,
clear,
yeah.
when you call him sometimes the colonial secretary, but
Yeah.
he is in fact a member of the British cabinet.
Correct, yeah. Yes, so that is a bit confusing, but it's almost always how he's referred to rather than the clumsier Secretary of State for the colonies. But yes, it's important to understand that he's a member of the British cabinet, Lord Grey.
Does that make it clearer, Justice Hennessy?
Very helpful. Thank you.
Okay,
As to why he would be suggesting that the colony should bear more of its own costs? 'Cause
Um,
he is a
yes,
UK parliamentarian.
absolutely,
right?
yeah. But I think in general that fit with his broad conception of the nature of empire in this era, and it's changing. You know that this is kind of how we saw it. So much of this correspondence between them is personal correspondence. They were acquainted. Lord Elgin's wife was in fact the niece of Lord Grey. Won't get
Thank
into
you.
all that.
That's
but
very
yes.
interesting, but I'm a little bit.
Yeah, of
worried
course,
about
we're
our time.
short of time. Yeah.
But just to reiterate as well, the role that Lord Elgin played seemed to me to be getting back to the point you made earlier today about the tension inherent in the role of Governor General, where you're representing really both the interests of the UK and the colony. Is
Yes,
that fair?
I think that's an accurate summation. Yes.
All right, so I think we're ready to move to slide 38.
Yeah, and so this is, I suppose, the other side of that equation, that we have Lord Elgin intervening on behalf of Canada with British officials, but we also have Lord Elgin at times reminding his colonial ministers, his ministers in the province of Canada, about costs that were their responsibility. And he did concur with Grey about many of these. One case in point that is, in fact, part of the history of these proceedings had to do with the province of Canada's response to the 1849 clash between the miners and Indigenous people at Mica Bay on Lake Superior. And of course, that was the conflict that culminated in the Robinson treaties. And in this case, Elgin reminded his own colonial government in Canada about an earlier communication with Grey. The issue, I should explain, was who should pay the cost of a military response to that conflict. And so Grey had said, and Elgin reminded his colonial ministers about this in Canada, that it's for the protection of inhabitants of Canada from any possible attack from foreign enemy that so considerable a force, as in a British force, is maintained in that part of Her Majesty's dominions. But to guard property against petty depredations and to maintain internal order in the province are more properly the objects of a police, for which it is the duty of the provincial government to provide. So here's a case where he is Elgin is drawing upon Grey's correspondence to remind his colonial ministers that if it is a matter that is an internal matter and not touching broadly British imperial interests, this ought to be a Canadian cost, that British forces are maintained in British North America for larger imperial questions.
And I think you expand on that on slide 39.
So, sorry,
Mhm.
for example,
Mhm.
is this in the correspondence? For example, does Lord Elgin say, therefore the Mica Bay costs should not be uploaded to
Yeah,
the imperial government?
Sorry, in the correspondence, yes, they do mention Mica Bay specifically. And it was particularly the issue of which government ought to bear costs.
And it's
for
an
it.
example of a local issue.
Correct.
Thank you. Go ahead.
So Grey again articulated the principle in another dispatch in January 1850, referring directly to the Mica Bay incident, and Elgin shared that dispatch with Canadians. So Grey,
Canadians meaning that
Oh,
his
in the
colonial province of
colony.
Canada
Sorry,
ministers.
sorry, just one at a time. So colonial means the Canadians meaning colonial.
Ministers.
yes, that is correct. So in this dispatch by Grey in January 1850, Gray emphasized that, quote, "It must be clearly understood that the expense of sending the troops is to be defrayed by the provincial government, by whom permission was given to the persons referred to explore for minerals. That government, having thought proper to sanction the formation of mining establishments in situations so remote, will of course be prepared to defray the extra expense which will be incurred in sending troops for the protection of the lives and property of the persons engaged in these undertakings."
Thank you.
And here we see another,
Slide 40.
oh, sorry, slide 40, another example of a particular controversy that sort of speaks to this question of allocation of costs and responsibilities. So I say this example arose over a British parliamentary debate over supply for the Indian Department in the province of Canada. Gray alerted Elgin to parliamentary sentiment expressed in the 12th of July, 1850 debate. And moving to the next slide,
41.
slide 41, I quote from that. Gray wrote to Lord Elgin in August 1850 to say, "There's another charge upon the home government."
Can I stop you there? The home government is.
Oh, sorry, British government.
Thank you.
Yes. "There is another charge upon the home government for the discontinuance of which you must be prepared. I allude to Indian presence. I understand that the feeling shown in the British House of Commons," and I've added the term British there, "against this grant was very strong indeed, and that it is quite impossible it should be maintained. It is argued, and I think not unreasonably, that the presents to the Indians are in fact the price paid to them for the land, and that as the revenue derived from the sale of land has been handed over to the legislature, it ought with the revenue take what is fairly a charge upon it." And one example that I read about, I read some of that debate. The British MP John Bright expressed his hope there'd be communication with the Governor General of Canada to get the, quote, "to get the Canadian Parliament to pay the grant to the native tribes, seeing that Canada," referring to the province of Canada, "possessed the hunting grounds for which this compensation was paid." If we could move to slide 42, please. Elgin wrote back to set Gray straight on points over which, quote, "some misconception prevails at home."
And at home being.
Being in Britain,
Britain.
sorry, yeah. "It's always assumed that the presents are given as compensation for land taken from the tribes, but this is not the case." Elgin explained that where lands have been purchased, annuities are given and paid by the province. The presents, on the other hand, have always been given and received as royal bounty in acknowledgement of the fidelity with which the tribes stood by their great father, the King of Britain, in various wars. Can we move to slide 43, please? It elaborates on this. Elgin noted that at the time the crown revenues were passed to the colony, with the colony in turn assuming responsibility for a civil list, this was not considered. He wrote, "No doubt it was a great omission at the time of the surrender of the territorial revenue that all this, as well as the cost of the Indian Department, was not charged on the civil list of the province. But will you believe it, not only were these items omitted, but no provision was made for the payment of the annuities." And that was the thing that I alluded to in slide slide 29.
And I just want to interrupt you there
yeah.
to go over this quote and understand what is meant by the surrender of the territorial revenue. What is meant by that here?
What they would mean there essentially would be the crown revenues. So I think what maybe the best way to explain this is that Elgin is making sure that Gray understands that the costs of these so-called Indian presents were really a cost that dated back to British alliances in wartime. It wasn't a direct colonial cost. And I think what Elgin is saying is that when we are moving now to a system under which the costs and the expenses would be together, controlled by the colony, that we need to make sure that everything was included. And this cost for Indian presence had not been transferred over to the colony. Britain retained responsibility for it because, and I'm speaking of these particular costs that the British Parliament was voting for, because those weren't about surrender of lands.
And sorry, who's saying they weren't about surrender?
Elgin was saying that to
Elgin is saying.
Gray. And this is, sorry.
Can I just interrupt? Because what I wanted to get at is, when it says, when Elgin says, no doubt it was a great omission at the time of the surrender of the territorial revenue. Is he talking about the surrender of the territorial revenue from the British government to the colonial government, saying now the colony can gather the territorial revenue?
Yes, I think that what he's saying is that these crown revenues that had been controlled by the British Crown in being transferred over and Britain
Surrendered. is the word.
surrendered, yes.
Yeah,
Britain did
surrendered to the colony.
to the colony, yes. That I think Elgin was making the point that at the time they should have been mindful of any residual expenses that Britain was bearing and transfer that over too. And he also is alluding to the fact that
Sorry, I'm gonna
sorry.
just
Yeah.
ask you if every time you say he in this
I'm
discussion,
sorry.
you tell me which he you're
I'm
talking about.
sorry. Can't think what, okay, I was
So
referring
someone was
to-
gonna be mindful.
Yeah, okay,
but,
Elgin was reminding Lord Grey. I'll try to be mindful of using their names. That is
Okay.
a bit muddy, yeah. Elgin was saying to Lord Grey that first off, that provision had not been made for the annuities, as we earlier discussed in the civil list of the Act of Union.
Okay,
And he also was saying at the time that Britain did surrender control over these crown revenues, they ought to have ensured that all the costs were provided for permanently in a civil list.
And really,
who's they?
I'm sorry.
No, it's okay. It's okay. I'm
Sorry.
just going to
Yes, of course.
keep working at precision.
Of course.
So they ought to have ensured.
Yeah,
Who was in the position of ensuring? Who is they?
the British government.
So
ought to have
if I get this right,
Mhm.
Elgin,
Mhm.
who's the Governor General,
Correct.
is replying to Gray
Uh-huh.
when he resets the meaning of presence. He corrects him.
Yeah.
And do I have that right? He
Um,
says the presents are different from the annuities.
Yes, I think to further confuse the issue, unfortunately, that they did sometimes refer to the presents as annuities, but
Okay.
they did make a distinction.
In this, on slide 42, he's making a distinction.
Yes, can we go back
42?
to slide 42, please? Yes, that's correct. Yeah, that's
Okay.
where he makes that distinction.
Okay, so he says they're not the annuities. They are royal bounty and acknowledgement of fidelity. In other words, they predate the treaty and they had something to do with wartime alliances.
Typically, yes, they did. Yeah, I didn't delve into the specifics.
I'm not
of
asking what happened.
yeah.
I'm just asking what he says.
Yes, I see. Yes, Elgin is saying that these presents are not annuities flowing from surrender of land.
Okay. And then he said, then you say,
Mhm.
and that's, I believe you're saying,
Mhm.
that's because he is trying to make a point that while he accepts this consistency between revenues and costs matching up, that is not a cost that matches, that should be matched with revenues, i.e. it's not a cost. I personally don't like the word surrender because it has a very
Yes,
particular
of
meaning
course.
here, but
Yeah.
devolved, because the
Yeah.
revenues have devolved or to the colony, they need not be matched to this particular cost. Is that,
I think I understand.
if
that
that's
to
what you're
be-
saying?
I,
And, and then the last point, someone says, is it Elgin again, who said, we should have done this. We should have paid attention to this matter.
yeah, I do
earlier.
find there's, Elgin makes a case for this is not a cost that, Elgin makes a case that Britain should continue for the time being
Okay,
to be responsible for this cost.
The presence.
The presence, I'm sorry, yeah.
thank you.
Elgin, I believe, also understands that ultimately all costs are going to be devolved upon the Canadian government.
Thank you.
Thank you. I think we can then move to slide 44.
Yeah, slide 44 was Gray's response to Elgin with respect to this question of so-called Indian presence. Lord Gray responded to say, I was not aware of the facts you mentioned, and they show a singular want of foresight in the government.
Can I stop you there?
Oh,
Which government?
British government,
Okay.
British government, when the territorial revenue was abandoned. But I do not think they will make any difference in the views of the House of Commons, the British House of Commons, and that the utmost we could hope to carry would be the continuance of annuities for the lives of any particular individuals for whom strong claims could be made out. And I should just point out here, he's using the term annuities with respect to the so-called Indian presence. So that does sometimes happen, that same term is used. He's not using annuities to refer to land.
Treaty payments.
Yes, treaty payments.
So what I can understand is ultimately the best you can hope for is that we might continue to be responsible for some of the presence, but not for the obligations coming from the treaties.
Yes, I don't think that anyone ever suggested that Britain would be responsible for the obligations coming from the treaties. But I think, yes, it is correct that Lord Gray is saying that these payments for Indian presence were not, as we at first imagined, payment for treaties. And the whole discussion in Britain's House of Commons reflected that misunderstanding
Okay.
that they were. Yeah.
So then when we move to slide 45, this becomes really your opinion, your take on all of this historical background you've led us through. So
Yes.
can you explain then what your opinion is on all of this, beginning at slide 45?
Yes. So what I've inferred from this, and it is my own opinion, is that the discussion, the communication between Lord Elgin and Lord Gray reflects a particular understanding. And I've said the fact that these payments were not compensation for land, but rather
Sorry, the word payment.
of the payments referring to the Indian presence, as they were calling them. Yeah. The fact that these were not simply compensation for land, but rather a sort of diplomatic tribute for a military alliance that served British interests, complicated the issue over whether the colony could with justice be asked to pay for them. I'm not so much, I didn't delve into the justice of that question and whether it was indeed just that the colony be asked to pay for them. But what I do comment on is the apparent assumption, both by Lord Gray and by those speaking on the matter in the British House of Commons, that had the presence indeed been compensation for land, in other words, had they flowed from a treaty, the case for transferring the expense to the colonial government would have been more clear cut if the colonies received the benefit of the land they should pay the costs associated with it. And indeed, they were paying the costs associated with annuities that flowed from treaties. The colony was paying, I should say.
Your last comment is, and indeed, the colony was paying.
Yes,
The
for
cost of-
annuities that flowed from treaties.
Thank you.
And on slide 46 is more of your take on this.
Yes, this again is an opinion, is an inference drawn from having read this body of correspondence over this formative period. This period that inaugurated responsible government. So again, I'm referring to correspondence between the Governor General, Lord Elgin, and the Secretary of State, for the colonies, Lord Grey. So my take on that correspondence is that it reveals the hardening of the principle that colonial expenses should be borne by the colony, that both revenues and expenditures should be transferred to the colony in tandem. Only those costs that clearly stemmed from imperial interests or imperial causes could justifiably be placed on British taxpayers who enjoyed none of the benefits.
All right, I think we're now moving to a slightly different topic on
Mhm.
slide 47.
Yeah.
About the Robinson treaties in particular, because as I understand it, this correspondence between Grey and Elgin is happening in 1850, but it's not really dealing with the Robinson treaties. And now you've taken us to the point in history where we're talking about the Robinson treaties.
Yes, it seemed to me important to kind of establish the basic chronology of where this fits in. So I've said this was the era in which the Robinson treaties were concluded. I've said my mandate does not include a detailed examination of the context of the treaties. I only recap some relevant points with reference to the Superior Treaty, which I understand is what we're presently concerned with. And sorry.
Yeah, so then on slides, I see on slides 48 and 49,
Mhm.
you quote from the treaty,
Mhm.
and you quote in particular from, on slide 49, from what we've called the augmentation promise.
Yes.
And I'm going to suggest it's not necessary to read through these because the court and parties are well familiar with these quotes. I think, and I know you are as well, having
Sure.
prepared the report, I think we can probably skip to slide 50.
Okay. So yeah, it's like,
Unless, I don't mean to rush you, unless you yourself wanted to
No,
review it again.
no, I would
Okay.
fully agree that the
All right.
court knows this very intimately. So here I'm summarizing my reading of this, of these treaties. I've said that the annuitants are thus promised a fixed sum, but further payments were also deemed possible depending on certain conditions, notably the yield of the ceded territory. In this provision, the Robinson treaties are distinct from others. And while the treaties say the annuity payments, quote, shall not exceed £1 or $4, they then allude to, quote, such further sum as Her Majesty may be graciously pleased to order. So what I've said here and what I think is important for what I'm trying to address in my report is that this is not then a one-time fixed agreement, but an implied commitment to share the future proceeds of the territory. And when considering the financial provisions that need to be made for this treaty, and especially capitalization of it, this is the thing that makes it so challenging. The need to make an arrangement for an unknown, and I would say unknowable, future obligation.
And here you're referring specifically to, you note, for example, that the treaty includes the phrase such further sum as Her Majesty may be graciously pleased to order. And this is this implied commitment to share the future proceeds. Anyway, I think I'll leave it at that. Let's carry on to slide 51.
Okay, so I'm, again, here, I should stress that I'm strictly quoting what others have said about the treaties. I make no claim to being an expert on the treaties themselves. So I have here a description by E.B. Boren, who had been asked by the Ontario government, we're skipping ahead to the 1890s, he'd been asked to prepare a report on the Robinson treaties and describe the process undertaken by Robinson in 1850 as an entirely new departure. This was his term. Boren said, prior to 1850, quote, the considerations granted usually consisted of a fixed or lump sums paid down. He further explained that thus, under these older treaties, the liabilities of the crown were always fixed and determined and therefore limited. Boren also suggested that the clause in the treaty, quote, securing and referring to the indigenous parties to the treaty, to resume the quote, certain prospective advantages was, as he believed in 1890, sorry, in 1895, I guess specifically, a new and dangerous departure, was his phrase, from the usual policy, insofar as these obligations were, quote, vague and indefinite. For although no Indian could claim more than $4 in any 1 year, no limit whatever was placed to the number of individuals who might, in the course of time, become entitled to that amount of annuity.
So here, Professor Messamore, I think you've identified in these two slides really two reasons why the liabilities flowing from the Robinson Treaty were unknown and unknowable.
Yes.
And one of those you've taken us through on slide 50 was this implied commitment to share future proceeds. What made that unknowable?
Well, I think, yeah, as you say, there's two grounds on which it's unknowable. One being that the number of annuitants might change.
And that's the point that Boron made.
Yes, exactly. Yeah, the other one being that if there is indeed an implied promise to share future revenues, then we can't capitalize at the time of Confederation the sum that might be paid because no one knows what those future revenues would be.
Thank you.
Which is not mentioned by Boron. Boron's worried about the population. And-
Well,
or
I
do you
think
say-
he kind of refers to it. He said, yeah, I mean, he said that the obligations were vague and indefinite. I think well, yeah, but then he also says, you know, no Indian could claim more than $4 in any 1 year, which seemed to be the basis on which people were treating it in the 1890s when this whole question was revisited. It seemed to have been almost temporarily forgotten. You know, they would allude at times to this such further sum phrase. And yet you see over and over again, without qualification, people using the phrase not to exceed $4 per person. So it's not entirely clear to me in the context of this whether Boren is fully acknowledging that ambiguity or not.
Thank you.
All right, we're ready to head into something a little bit different, which is the conditions leading to Confederation. And that starts on page 53 of your report.
Mhm. Yes, so we're on slide 53. Yeah, the point I wanted to make initially is that the notion of some sort of confederation for the British North American colonies was not a new one. This had been in discussion for a very long time. Discussion even predated the American Revolution. And I offer the example of the 1754 Albany Conference organized by Benjamin Franklin just before the outbreak of the 7 Years' War. So that was an example of an early plan that might have looked very different, that would have considered a wider union. Yeah.
So slide 54.
And there was a flurry of ideas discussed in the 1850s. And my conclusion is that the most influential was the scheme advocated by Alexander Galt, who was a member of the province of Canada's Legislative Assembly for Sherbrooke. And he was the Inspector General, that is the Minister of Finance, in July 1858. So this is within the province of Canada. He's an important figure. Sorry, did you want to wish to ask a question? No. When Galt put forth in 1858 resolutions in the Assembly calling for a committee to consider a federation, the reception was cool. And I've quoted a historian here, Upton.
And I don't think, just in the
okay, we
interest of
don't need to-
time,
Yeah,
that,
okay. Yeah.
I think we made the point, it was a cool reception.
Yeah.
But what's of interest, and I'd like you to explain more about, is the 1858 proposal,
Mhm.
which you get into at slide 55.
Correct. Yeah, so I say that in October 1858, Galt, along with George Etienne Cartier and John Ross, drew up a memorial for the Secretary of State for the Colonies, Sir Edward Bulwer Lytton.
Can I just stop here and say,
Yeah.
this would be the modern replacement for the former Lord Grey. It's the same position?
Yes, it is the
Right.
same position. It's, I suppose I might at this juncture say that this was a portfolio, the Secretary of State for the Colonies, that had, I think I allude to this point in the report, very high turnover. And in fact, it's also significant to note that before 1854, the ministry was actually Secretary of State for War and the Colonies. So this minister had a great deal on his plate, and there was a virtual revolving door through that office. At some cases, many incumbents within a very short period of years. And I mentioned that because I think it's important to understand that they weren't necessarily, the colonial office was not necessarily plotting long-term plans for their colonial possessions, including Canada in this era, that typically incumbents hadn't been in the office long enough to even know what had been considered by their predecessors. And it's further complicated by the fact that a lot of the relevant correspondence was taking place by means of private letters to which their successors as Secretary of State would not have access. So I guess I want to make sure that's clear, that there's not really any great organized long-range planning taking place with respect to Confederation or indeed most other colonial matters.
From the
British
perspective of the
Colonial
British
Office,
government,
yes,
the British
correct.
colonial government.
Yes.
Right, okay, so I've kind of interrupted you here then on slide 55.
Yeah, well, my point being here that in October 1858, this delegation visited the Secretary of State for the Colonies with a document proposing that the imperial government, the British government, authorize delegates of the British North American colonies to meet, to talk about a new federal arrangement. And the other important point is I think that Galt's ideas seem to be very much the driving force behind this proposal.
So can you explain for us on slide 56 then a bit more about this 1858 proposal?
Yes, I've just mentioned a few particular points of it. Structurally, it would rather resemble the system that was ultimately put in place. There would continue to be a governor general. There would be an upper house or a senate. And I mentioned that was the plan was for it to be elected. And that was because at this time in the province of Canada, they were making a transition to an elected upper house. So this wasn't kind of a bold departure is my point, but rather a concession to the status quo. so an upper house or senate, and a house of assembly that would be elected on the basis of population, and an executive responsible to the legislature. So structurally, apart from that important difference of an elected upper house, this would be the system that would prevail.
And on slide 57, you go into other elements of the 1858 proposal that will help explain why you feel this is relevant to your report.
Yes, I don't imagine the court would like me to read this whole thing, but I do point out that, and correct me if I'm wrong, but in this 1858 proposal, Galt broadly laid out what the powers of the federal government should be, and added the point that they should deliberate on whether the federal powers should just be restricted to those things we've named, or should embrace everything not specifically entrusted to the local legislature. And the thing that I've highlighted in my slide here is that one difference, I suppose, in Galt's 1858 proposal, and the reason that I even mention it, is that it would have granted to the federal government public lands, and then said also that the net revenue from the public lands in each province would be its exclusive property, except in case of the territories. And so that was one aspect of Galt's 1858 that proposal that significantly differed from what was ultimately decided with the Quebec resolutions.
Can I just go one
Yeah.
step back?
Of course.
You said Galt laid out what powers of the federal government, laid out the powers, what powers should be to the federal government.
Okay.
And
sorry.
then you
Yeah,
said,
mhm.
I thought, or whether they should be more general.
Yes,
Is
that's
Galt
correct.
proposing that there should be a discussion of whether they should be narrowly defined as per his list, or more general? Was that his?
Yes, he does
suggestion?
say that. He uses the phrase mature deliberations should happen over whether the federal government's powers should be restricted to those named, or should embrace all things not specifically entrusted to the local legislature.
So mature deliberation of the powers of the federal government.
Yes.
And then two options, either a list, restricted list, or more general.
Yes.
Okay, thank you. And then you were making comments about public land
Yes.
as being on the list of restricted. His original list.
Yeah, he did provide a list that included customs and excise, postal service, militia, these kinds of things that did indeed come under federal jurisdiction ultimately.
But ultimately, public
But
lands,
also public lands, correct?
Right.
Yes,
public lands are included on that list, but ultimately public lands were not included.
that's correct.
Okay.
Yes, and but in Galt's 1858 plan, they were.
Can I
But-
interrupt there? We're not just talking about public lands. We're talking about the net revenue from the public lands.
Yes, I was just about to,
Okay.
to move to that point. He says public lands, but then he says that the net revenue from those public lands would be the exclusive province, or sorry, the exclusive property of each province. Yes.
So can you explain what he really meant here?
Well, I think
What he intended?
I think my sense of it would be, would it be possible to move to the next slide? Because I
Sure,
think
yeah.
I might address that very
and
point
58.
here. That I've said that it was noteworthy that his 1858 plans, or on slide 58, would have placed public lands under the control of the Dominion government, with the net revenue going to the provinces. And I've added again my opinion here that the arrangement might have avoided the issue with which the court must now contend, because it would have been understood, I think, that what would flow to the province would be the net revenue from the public lands after costs had been deducted.
And those costs would include what?
He did not specify what the costs might be. Is that, sorry, if we go back to that slide, what does he?
No, I think yeah.
I'm sorry?
He doesn't, I think he just speaks about there being net revenues.
Yes. I mean, my sense of it would be that it would be costs associated with those public lands.
All right. I'm skipping over the end of slide 58, where you talk about educational and judicial purposes.
Yeah, I just felt that it was important to be thorough and some of these things won't be of interest, I think, but I felt like it's important to include it.
So, and then on slide 59, you go through the limits in the colonial office, and I think you've already mentioned
Oh, I
this.
have, yes.
Yeah,
Yes.
so we can probably,
Yeah,
although you,
I give one specific here. I see between 1851 and 1855, there were 8 secretaries of state for the colonies. So that's kind of my point. Yeah. 4 between 1858 and 1859. And I mentioned this, I just say it probably stood in the way of Grant's scheme gaining traction. You know, you wouldn't be in a position to think long-term if you've only been a few months in office at best.
of Galt's scheme,
Correct.
yes,
Yeah.
gaining traction, right?
Yeah. Sorry, on slide 60 then. I've just given a very brief rundown of these well-known causes that gave the idea of a wider federation impetus in the 1860s. My point being, if the idea had been around for a long time, why is it suddenly gaining traction in the 1860s? The first cause for that, the first factor would be defense. The feeling was strong in Britain that Canada should bear the cost of its own defense, should improve its defenses. And the thinking was that Confederation would facilitate that by allowing the individual colonies to plan and pool their resources.
And then slide 61,
Yes.
another factor.
Another factor is the railway. Confederation would facilitate building an intercolonial railway to connect central Canada to the Maritimes for commercial reasons and for defense reasons.
And then slide 62, economic ties.
Yes, so the other reason was to build economic ties amid the pending loss of the existing US trade deal. There had been since 1854 a reciprocity treaty in place between British North America and the United States. The Americans announced their intention to cancel that. And so the thinking was that some better economic alternatives should be explored.
And then on slide 63 is your last factor, political dysfunction.
Yes, for the province of Canada, as distinct from the rest of British North America, a new federal arrangement could address this chronic political instability that was, I believe, a product of the artificial equality of representation for Canada East and Canada West at the time of union. So the court will recall that I've said that there were equal number of representatives in each district of a single legislature for the province of Canada. And this made it difficult for any one party to keep the support of the colony's legislative assembly for on a sustained basis. By June 1864, for example, there had been 4 unstable ministries within 3 years, and a ministry had just been defeated after only 3 months in office. Historians sometimes use the term political deadlock for this period of Canadian history.
Thank you. We have a few more minutes before the break. If everyone's content, I'll carry on with a few more slides. So here now we're into sort of the third broad topic. This one's called Confederation Conferences and Ideas about Finance. And that begins really on page 65. Can you take us through that, please?
Yes. So I refer to the initial Confederation Conference at Charlottetown, Prince Edward Island in September 1864 that secured a general agreement to move on to more substantial discussions. There had been kind of a broad base of support flowing from that PEI conference to consider Confederation. And more detailed discussions followed just a month later at Quebec in October 1864 and produced the 72 resolutions that would form the basis, I'm sorry, it's a typo, it should say of the British North America Act.
And you have a correction to make on slide 66, I see.
I do, yeah. There is an error of fact that I discovered upon rereading it. I attributed
Rereading your report.
rereading my report, sorry, yeah. I attributed a comment to John Hamilton Gray, Premier of Prince Edward Island, that was in fact made by another delegate to the Quebec Conference, also named John Hamilton Gray, who was a delegate from New Brunswick. And this delegate from New Brunswick, John Hamilton Gray, was the one who wrote the detailed account of the Quebec Conference. John Hamilton Gray of New Brunswick would be the same person who would later serve as one of the Section 142 arbitrators that I'll discuss later.
So these two individuals had the exact same name and lived
Exact same name,
almost the
first,
same
middle, and
time
last,
period.
and both delegates to the conference. And I unthinkingly added in Prince Edward Island when I meant to say New Brunswick. It was the other John Hamilton Gray. Yeah, I don't think it matters. I
No,
just mentioned it as an error of fact that should
It's
be
also
clarified.
a point of
Yeah.
interest, isn't it? All right, so the actual quote then, you deal with at page, slide 67.
Yes, so the misattributed remark concerns Galt. And so this is why I include it, because it's about Galt's mastery of the financial details of Confederation. And that was a point on which other delegates also remarked. So John Hamilton Gray of New Brunswick wrote that Galt pointed out with great power, his words, the detrimental way in which the colonies' conflicting tariffs operated to each other's disadvantage and the benefits that would flow from freer trade between them. Gray said that Galt, in a speech of 3 hours, statistics were piled on statistics, confirming his various positions and producing a marked effect upon the convention. I think in the slide that follows 68.
68, yeah.
Yeah, refer to, we don't necessarily have to go over this, but other people, as I said, have remarked on that same thing, that all questions of finance were applied to Galt. Andrew Archibald MacDonald said, there was of course more than one MacDonald there too, but Andrew Archibald MacDonald said that Galt has all this information in his head and doesn't have to refer to printed statistics.
Good. So, and let's go through slide 69 before we actually get to those Quebec resolutions then.
Yeah, one of the other points that is mentioned is that at the discussion at Quebec, where it looked as though difficulties had arisen over financial questions, Galt met with finance ministers of the other colonies in a separate committee and reported back the following day with some proposed solutions. And those negotiated terms would form part of the Quebec resolutions, the 72 Quebec resolutions.
Okay. So I see that you start going into those resolutions on slide 70, and perhaps just before we break, you can explain why the Quebec resolutions are so important, because I see you've devoted quite a number of slides to the Quebec resolutions. And can you just explain for us what's so relevant about Quebec resolutions?
Okay, I guess insofar as there was not from either of the Confederation conferences an official record of what transpired, everyone seemed to agree that it was best that that people be free to speak openly, to work out ideas. And so the resolutions reflected the fruits of those conferences, that the Quebec resolutions is really, in essence, the record of what was agreed upon, the agreements that would form the basis of the British North America Act.
Of the conferences, you mean the Charlottetown and the Quebec conference?
Well, specifically the Quebec conference, the Charlottetown conference really was a broader agreement. Quebec was the hammering out of the details.
So reflect the fruits of the discussions at the Quebec conference.
Yes, that would be better put.
Thank you.
Yeah.
And ultimately, these Quebec resolutions appear to have formed the basis for the ultimate agreement of confederation. Is that right?
Yes, that's correct. And I suppose one of the other things that I put them all on my slide presentation just because I thought it's easier to put them in and skip over them if they were already well understood. I suppose I also wanted to make it clear, I suppose, that the financial aspects of the Confederation Agreement did not substantially change, that in fact the debt allowance question didn't change at all, that there was a degree of consistency between what was agreed to at Quebec as reflected in the Quebec resolutions and what ultimately formed the financial provisions in the BNA Act.
Great. So I did promise a break at 11:45. Do people feel a break would be good?
I don't need a break.
So what, I want to work backwards from the end of the day.
Mhm.
So if we break for the day at 3:30, what should be our, and we're taking a break now and it is
Well,
10 to 12.
I guess because we started, maybe this can be off the record, right?
Now we can.
Because we started